numbers, but
Okay, you can go ahead and start.
Good morning, everybody. This is Julie. Very nice to know that you're out there, even though I'm sitting here in my home, like you're sitting in your homes, looking at the computer screen. So I'm Julie Macfarlane, the Director of the National Self-Represented Litigants Project and a professor at Windsor Law. And we've put together this webinar for self-reps, along with my colleague Aisha Amjad, who's about to introduce herself. And we're hoping it's going to be helpful this morning. Aisha, want to say a word about yourself?
Sure. Thank you, Julie. Hi, everybody. My name is Aisha Amjad. I am a family lawyer in Toronto. I actually practice family and criminal law. And I'm here and I'm happy to help.
Thanks, Aisha. So just a couple of things as by way of introduction for everybody. First of all, we have to underline that this is not legal advice. I think most of the people listening will know why we have to say that, but we're going to be as helpful as we possibly can with procedural information because there's a lot of information out there and some of it is frankly quite confusing. I find it confusing and I've been swimming in this pond. Okay, so I think most ordinary people will find it confusing. We're going to try to cut through some of that this morning and demystify it a little bit. The slides that you're going to see will be available to you on the NSRLP website and also to anybody else that you want to direct to them. And as well, very kindly, our hosts today who have made this software platform available to us for free, Trish Mongoin and her husband Marcel, they are recording this and it will also be available as an MP4 file on the website if anybody wants to listen to it afterwards. You can ask questions. There will be a place that you can type in your questions and Aisha and I will see them as they come up. And we will, respond to them as best we can. So unfortunately, that is the limit of how much we're going to interact, but let me just say, I hope you're all in out there, and we are too, and let's get some work done. So this is what we're going to talk about today. We're going to talk about issues around the closure of the courts because there are a lot of procedural matters that will affect you, in particular if you are trying to navigate without a lawyer. There are matters of adjournments, there are matters of urgent cases that we describe as best that we can to you and discuss in some detail. There is facility for video and teleconferences for some of these matters, something that some of us have been encouraging the courts to offer more of for years, so we're hopeful that this might actually start to change that culture. There are impacts on filing deadlines, which is very important, I know, for those of you who are representing yourselves and feel the pressure of time urgency, and we're going to explain how those have changed. There are also changes in how you now can swear an affidavit. Usually you take that to a notary or a lawyer, and you're not going to be doing that physically at the moment, and we'll explain that. And then the last thing we're going to talk about are limited periods, which, of course, to an ordinary person sound the same as filing deadlines, but in the legal system, they're not. So we're going to explain that as well. So I'm going to begin. Basically, across all the provinces and territories, and although today we will be bringing you some particular examples from primarily Ontario and BC, all the family and civil courts at all levels in all the provinces and territories are now closed. They're not holding in-person hearings. So that means that your matter, at whatever stage it might be, whether you had a trial date coming up, maybe a case management conference or a settlement conference with a judge, perhaps you were making an application and you had your first hearing or a motion, or something that the other side had arranged and you were required to appear at, is now probably adjourned either to a tentative new date or sine die. And you see this expression, sine die, it means without a date. Now, this information is changing all the time. In particular, the idea of when the courts in any sort of country might begin to have hearings again. And we have a page on the NSRLP website on court closures and procedural changes that we update every day, because this does change every day, some of it every hour. So depending upon where you're filed, what court you're filed in, and what jurisdiction, which province or territory, you should be able to get up-to-date information there. It's organized by province and territory. And we also give you links to the court websites so you can check if it has changed in previous 24 hours, but we are updating that pretty much every day. So basically, the simple part of this is everything is on hold. That is the simple part. So here are some examples. The BC Supreme Court saying everything is on hold for further notice. The Court of Appeal says until after May the 1st. Although we fully expect that in the next few weeks, they will post again and make that another date. But at the moment, it's May the 1st. The Ontario Court of Justice until May the 29th. The Superior Court until further notice. The Court of Appeal doing something a little different, asking parties to consent to an adjournment, or in some cases, a hearing based on written material. So, like I say, everywhere is a little bit different, and you want to check. But this is the basic picture, and you confirm that information on our page. Now, if a case, and we're going to talk about some of those cases in a minute, that is going to be the court has agreed to hear, either because it's what they call an urgent case, and we're going to describe a little bit more about that in a moment, or because it's some type of hearing that the court feels that they can hear. And again, you have to refer to the court websites and our page for that, because some places are still some scheduling hearings, but they're doing them by teleconference or video conference. They're not doing them in the courthouse itself. And if you are someone whose hearing is proceeding, you should expect to be given information about calling or video conferencing into that hearing. Those are the exceptions. However, and I'm going to ask Aisha to take over here, here is the rub, I suppose, for family self-reps. Aisha.
So what I've been finding with many of my clients is they're asking me, well, we have an existing court order. What does this mean right now? And my advice to my clients is that existing court orders prevail at this time, which means, you know, it's not a time for you to go and unilaterally make decisions against the order. However, it is a good time to perhaps consult with the other side and come up with some sort of arrangement when it comes to things like parenting, time and access, you know, to try to work with the other side, because everything is essentially on hold right now. So nothing is really moving. If you want something to move, then the best thing to do as a starting point is to have that dialogue, if you can, with the other side. But having said that, court orders are in place, and it's you know, you do have to abide by the court order. I don't know, I'm trying to make sense of that myself, and it's hard to explain, and I'm sure with every case it's different, but that's sort of the message that I'm giving my clients. Okay, so all courts are prioritizing and making exceptions for hearing urgent or emergency cases. And I guess the big question that comes out of this is, well, is my particular case urgent? And most of the time, everybody feels like their particular case is urgent. However, when the courts are actually screening cases right now to determine whether or not your case would fall under something that is considered urgent.
Next slide.
I'm sorry?
Next slide.
Next slide, sorry. Yeah, next slide. So.
Oh, I've missed one, sorry, there you go.
So the courts have been helpful, though, at least us lawyers as well, in determining what is considered urgent. For example, in the Ontario Superior Court, cases that concern the safety of a child or a parent For example, a restraining order or restrictions on contact between the parties. The well-being of a child, including essential medical decisions or the wrongful removal or retention of a child. This goes back to what I was saying about, making unilateral decisions, not a time to be doing that, especially when it could put the child at risk for putting them in harm's way or removing them. And then also going back to that, sorry, I'm trying to read and talk at the same time. Dire issues regarding the parties' financial circumstances, initial hearing in child protection case after a child has been brought to a place of safety, and then civil cases where immediate and insignificant financial repercussions may result if there's no hearing. So just to give you some examples, dire parties' financial circumstances. In terms of child support orders, this is a time when many of us are going through financial difficulties, and maybe your existing child support order is becoming difficult for you at this time. Again, bringing something like that to court, it would have to depend on the circumstances of your case, whether or not it is considered a dire financial circumstance, which means it may or may not be urgent. So just looking at your whole financial picture, maybe talking as a lawyer, I'm talking to my clients about some of the government assistance that's available right now, taking advantage of that and applying for the child benefit tax. Actually, that one is automatic, but then there was another one that came out yesterday, which is an additional $200 a month that every parent gets for their child, and maybe just working that out with the other side, given that only one parent can apply for that. Maybe the parent who's having financial difficulties can look to that. Just coming up with ways to sort of help that financial burden right now with the other side.
Can I just jump in here, Aisha?
Yeah.
I mean, this is just the list that the Court in Ontario has put out. And if you look
Right.
on our court closures page on the NSRLP website, you'll
Right.
see that, unfortunately, every court has their own list.
Right.
They all kind of the same.
Right.
At the same time, and we're going to talk about this in a little more depth in a moment, some of these expressions that you might be looking at now and thinking, well, I'm sure that would apply to me, such as the safety of a child or the well-being of a child. The courts are basically saying the existence per se on its own of the pandemic is not a reason to say that the safety of a child or a well-being of a child is being threatened. So we're going to try to help go behind this language, but this is, if you like, the place that you want to be in, is what does your court, you think you might have an urgent case, what does your court actually list? And you are going to, and Aisha's going to talk in a moment about the application to this urgent, you will want to refer to whatever seems to be the most relevant to you. Right?
Right. Yeah, it's very tricky because the safety of a child and pandemic, it's
so here's the next one.
Pandemic, yeah. So if you think your case may be urgent, there are 2 steps. Apply by email for consideration as urgent, following the instructions on the court website. Or if your matter is considered urgent, it will be scheduled for a video or teleconference. Now, what I've been telling my clients and actually doing myself is just picking up the phone and calling the courthouse and speaking with the trial coordinator and asking, because things are changing daily, and just to keep up with that, I find it's helpful to just call and find out, is it okay if I send an email now? Who will be receiving that email? And basically the same questions that I'm sure many of you have is the same questions that we have, because things are changing and there's no real concrete, rule in place right now. So.
Yeah. The other thing that I think it's important to know, and you will be able to see on our court close page exactly who you should email or call, all that information's on there. Right. But there is a screening process. Not every everybody who asks for their case to have an urgent hearing is being heard. We really can't give you too much more information about that at the moment because we don't know. I'm sure it's something that people are going to want to be asking questions about at some point. So the first hurdle is even to be accepted as urgent, and then the second hurdle is going to be a hearing, which would be by video or teleconference. And then the judge will decide or not they're going to change your current order as a result.
Right.
So there's a series of steps here, as Aisha has said.
Right.
Now, again, just if anybody has a question and you want to type it in, we will try and respond because we've got a little box down here. So please don't be shy. Write in your questions as we go through this. I'd like to do that. So one of the things that we've been doing at the NSRLP, and Aisha has been doing with as well, and a number of other family lawyers across the country, is trying to pull together these decisions that are coming out thick and fast. Most of them so far are from Ontario or BC. We're just starting to see some in other provinces and territories on those hearings. The person who's got themselves through the first hurdle, and now they have a hearing. And now the court has to decide, is this urgent? And so will we change anything that's currently going on with this family? So we had a little bit of a discussion about which cases we would give you, because there are probably about 35 now that I've seen as of this morning. But these were just a couple that we thought might be useful for you to see. And then there's another one on the next slide, and actually a new BC decision that came after we made these slides yesterday that we're going to talk about too. So just to give you a few ideas. Some of the parents who are concerned about their kids, of course, are where the kid is in another country. And this case was a request for a teenager who was at school in the US, in Utah, to come home. And the court did approve that because the border was about to close, and that was urgent to get him back in the country. On the other hand, I've also read a case in which the father has the children in Nigeria, mum is in Ontario. They went to Nigeria just for a visit with dad, and mum has been to court and asked the Ontario court to order that he sends them back. They refused that. At that point, it seemed to be too dangerous for them to be traveling. So there are some issues here about sort of relocating kids who are physically far away. And I think increasingly we're going to see courts unwilling to order a child who is somewhere else to move across a border. I mean, in some cases it's going to be impossible, but I think we're going to see some concern about ordering that. Case is a very interesting case. Aisha and I were talking about this just earlier, about a dad who has been in rehab, and he was not getting access. The mom stopped sending their child, over for access, which was ordinarily supervised, because she was concerned that the child would be, amongst other residents in this facility and would, stand a greater risk of contracting the virus. And in that case, the court sympathized that that was going to be a risk to this child. And instead, they made an arrangement that dad was going to move back to his own mother's home. And she had been in isolation, and she could supervise access. That would enable the kid to continue to have access. I mean, I think, something that it's important to bear in mind as a general principle, and, Aisha, I'm sure, could weigh in on this, is that the courts generally want to keep existing arrangements in place. I mean, it's certainly the case that legally they're in place until the court removes them, but they also just want to keep them in place. And they want to keep them in place because they want to ensure the continuity of contact where there is some kind of an access arrangement with the non-custodial parents. So, I think that could start to change over the next few weeks, but at the moment, the trend is very much for the court, even if they agree to hear an urgent application, to tend to err on the side of leaving the existing arrangement in place, which, you know, may or may not change. The next case is a money case. One of the things that I should go ahead, Aisha.
Julie, I was just going to add in the case that you're describing, and you were just discussing, the mother unilaterally decided to stop access, right? And as you mentioned before, the courts are going to be reluctant to condone this type of behavior. So even if there is a genuine concern, and in this case there really was, to just unilaterally stop access and take it upon yourself is not something that is going to be, you know, looked at in the most positive light from the courts, which you mentioned. So I think that was just that point. That was a point that I've been trying to explain to my clients, is that, you know, making these unilateral decisions probably won't look good for you if or when this even gets to court. So
we, you know, and we'll do another webinar actually next week about this in more detail, you know, why we're encouraging you to try to communicate with the other side. And even if they don't communicate back to you, you need at least to show you've tried.
You've tried, exactly. Yeah, just make the effort. Absolutely. Yeah, sorry, go ahead. Go on.
No, that's fine. Thank you.
Yeah.
You know, I just reiterate as well, not unfortunately describing a sort of easy, magical science here. You know, all of things are being looked at by different judges in the context of that particular family. And so all we can do is give you the best advice from what we're seeing, and we're trying to synthesize this all the time.
Right.
The things in the list that Aisha explained to you a few minutes ago was dire financial circumstances. And the third case on this slide involves someone who basically took $755,000 worth of money out of the party's joint line of credit, which was a very large line of credit, I have to say. And that was clearly seen as being urgent, and the funds were ordered returned. Now that is, you know, I think we can all agree, fairly extreme unilateral measure. And that was something that the court was willing to respond to and to order that the funds be returned. It's quite different from cases in which there may be understandable difficulty in people meeting their support obligations. And again, in those cases, definitely going to expect people to try to work out, even if it's a temporary agreement for something that is different than is normal. And again, you know, that's the kind of thing that we would encourage you to try to think about and plan for. If you know that you're unable to make your support payments, or you know if the other party is going to be unable to make theirs as normal because of losing payment, then you should try to do something to work that out between the two of you, rather than expecting that the court will weigh in. I can see that the court's going to weigh in fairly extreme situations, but again, they're going to know that you've made some effort to try to work it out. And, you know, and I feel bad saying this because it's really hard for people to do this, and really hard to do it under normal circumstances, even harder in the middle of a pandemic, for goodness sake. But that is what we're in front of the courts. I want to add anything to that?
No, you covered it. That's
okay.
The main takeaway I see from that is just really trying to figure out a way to work it out with the other side. That's really what I think is beneficial, because nothing's moving right now. You know, it's sort of on pause. Everybody's life is on pause, and while the struggles are continuing, the recourse is not there. Limited. It's limited. Yeah. It's limited, right? There's only so much that the courts are going to do right now. So that's really been our focus right now.
So this case that we were going to mention to you this morning, you know, maybe is the most practically useful we've seen so far. I mean, I'll be honest with you, I'm not sure some of these cases are all that helpful. But this one, in some ways, I think is quite helpful. And it's now been cited with approval by the court in BC, which I'm going to mention in a moment. And that means that that gives it an additional weight. I mean, those of you who've prepared court materials and done legal research will know that for a decision then to be cited by another jurisdiction does give it some additional weight. And in this case, mom was worried that dad wouldn't observe social distancing. She didn't want their child to go for their regular access, overnight access as a result. And the court said that although they recognized that she would feel concern, they looked at the context of the case and saw that there was no particular, specific thing that the mother could point to which suggested that dad had not been observing social distancing. In other words, they asked her to produce some evidence that he was not complying with the public health directives around that. And she couldn't do that. And of course, if you are sharing, access to a child between a distance, I'm not sure how you can get any evidence. I mean, of somebody actually breaking social distancing directives. But they were very clear that simply being worried about it without being able to point to very concrete things, concrete examples, was not going to be enough to either deem the case urgent or to do anything to change it and the existing order. And the judge said this: right now, families need more cooperation and less litigation. And I think that, that's a very understandable message, and it's part of the message we've been giving you. But I'm also concerned that it's going to be so difficult for parties who are physically separated to really be able to bring this kind of evidence to the court, that this is not perhaps the most helpful. And today we saw a decision out of British Columbia, which actually seems to be a little bit more practical. And it certainly cites this case with approval. But the other thing that it does is it includes in the decision, and this is the case of NJB versus SF, but this is an oral decision. We can post it on the website, but it's not something that will yet be reported in CanLII or any of the sources you might normally use. But that decision has included the recommendations from Chief Medical Officer in British Columbia. And I think actually is quite useful and practical. So for example, it says, if a parent has had contact with an infected party, they should disclose this immediately to the parent. Or if they're infected or ill with symptoms or need to be tested, they should not take the child. There should be no face-to-face play dates. So, and there are a few other pieces here. These are the kinds of things that we have tried to capture and are going to continue to add to this in our templates clauses that are also on the NSRLP's website. Things that you could present to your co-parent and say that you need them to agree to this, you need them to sign off to this, that if they had with an infected party, they would be transparent, that there will be no play dates. And, I understand, really, this is not a magic bullet. If you've had a difficult relationship, it's going to be difficult for you to trust what the other party will say. But this way, at least, you can try to manage what you know are the risks, and you can put them in writing. And I think the medical officer's recommendations are a really good place to start. You can, ensure that the other side has at least seen these, and you can point to these. And if you feel 2 weeks from now that they are not regarding them, if you have some way of thinking that they're not regarding them, then you can start to put together something that looks like evidence. And you can also tell the court, if you were to make an application, this is what we agreed, this is what we signed off on, and I don't think that they are keeping 1 and 2 or whatever it might be. I think they've been breaking, obligation 3 about play dates or whatever it might be. But you need to be very clinical and organized around what these standards would be, and at least try to get the other side to agree to them. Aisha, do you want to jump in on that?
No, that's you've covered it, Julie.
Okay.
Yeah, the important part also. What I like what you added was to revisit in 2 weeks and coming back to it, because things are changing every day and we don't know what rules will be in place tomorrow. Like, for example, we just now learned that wearing masks, even if they're not surgical, is an example of what our health officers are saying now, that maybe we should take that precaution as well if we are going out into the public. So things could change in 2 weeks, and revisiting that, or revisiting the terms, I think would help, right? Yeah.
Okay, and then there's a few slides here about what is not deemed urgent, and these really repeat some of the things that we've already talked about.
Yeah.
Nova Scotia says unilateral interruptions, one-sided changes in the evidence, disagreements about activities. That one I feel like may have to give, because activities presumably might include play dates or going to plans, which we're increasingly seeing closed down. Interruptions in paying child support or spousal support are the issues. So at this point, they're not seen as being an emergency, but again, it could change. And 2 cases in which the matter was not seen as urgent. One of them I've already talked about, which is it was mother seeking the children's return from Ontario to Ontario from Nigeria. I have it the wrong way around. I said it right the first time. Was deemed not urgent because of the concern of bringing children across borders. And then another case, which I think was an interesting one here in Ontario, Douglas and Douglas, the first case, the mother was withholding access because dad continues to work in Lowe's, which is open. It's a store. So the court saw this as an important concern, but it wasn't urgent. And they actually went on to do something that I think is also important for people to hear, although I feel badly saying that this is what the court is saying, but it is what they're saying. That if the mother were to withhold access in that situation because she was worried about dad maybe being exposed as part of his job at Lowe's, that might in the future be deemed to be inappropriate behavior. So in other words, if they were coming back to court in the future when the courts are open again, this could be used as an example of something that might reduce her parenting time or be used as an argument by the other side to restrict some of her parenting rights. So, this is a bit of a dark message, I think, but it's also a message that I think Aisha and myself both feel that everybody needs to have, that there could be consequences to doing unilaterally. Putting it very bluntly, it could come back and bite you in the butt in the future. So again, you need to at least do something to show that you have tried. For example, in that case, if mom said to dad, what are you doing when you come in off your shift? Are you, showering? Could we make an agreement that you do that? And he found that he wasn't, well, that might be different. But again, it has to be very concrete and very specific. There has to be some effort to have that communication.
Right. I think everybody's looking for assurances right now, right?
Yeah.
So just being able to give the other party some assurance that you care just as much about the children as they do. And that's really the message that, and I think your behavior, so long as it's in line with that, will show and could actually help you in the future if it does go to court.
Right.
Yeah.
Right. Okay.
So,
Thanks here.
Okay. What does this mean for the filing and procedural deadlines for my case? Well, again, as we talked about, every courthouse is somewhat different in their practice direction, and things are changing. However, nevertheless, there are some rules in place that they're trying to put in place for filing. I know one courthouse in Toronto has made a protocol of how many people can be allowed into the building, how far apart they have to stand. If and when they do file, a lot of the courthouses right now aren't really giving any dates. For process servers, at least the ones that we hire, it means probably having to go back again to get a date. So in that case, we've really had to look at each case by case and figure out, is it really worth it right now to even file an application? Because a lot of the times they're not gonna be given a date. Then if the other party needs to be served, they don't have a date to be served with. And serving is also another big issue, because many process servers right now are finding that part difficult, especially with social distancing, and the people who they're trying to serve to are not answering the door, don't want to receive a package, and in some cases in normal times this could all seem like somebody's evading service, but during this time it could be reasonable to and for many people not want to do that. And so I've been having to tell my clients that maybe we need to hold off on this right now. Maybe this might not, because what's going to happen anyway? You're going to serve and nothing is going to happen because the courts aren't giving dates to actually hear, even for a first appearance right now, you're having to wait, and it's often to a future date somewhere in the future, or maybe no date at all. So what I'm finding is that I really have to have that talk with my clients that let's hold off on this right now. Let's pause on this right now, especially when things may not even move for the next few weeks or so. So I'm sort of revisiting that every couple of weeks. I understand it's important for my clients, but at the same time, just managing that expectation is helpful because just lessens everybody's anxiety when it comes to what's going to happen next. Well, nothing's going to happen because we're not given a date and we don't know yet. So that's my choice I'm advising my clients to just wait, and if it doesn't have to be, then let's give it some time. Let's try to have some discussions in between.
And I think the other thing that's important for you guys who don't have lawyers is that it also means that any kind of deadline to respond, which is something that causes enormous anxiety, I know often to self-reps who know they have a certain length of time in which to respond to the other side and to file materials in response to whatever has just happened. All of those deadlines that, often keep you up at night trying to meet, those are also suspended. Right. So, that is, I suppose, the silver lining here a little bit, that with a couple of exceptions, and I think they're on the next page, you're not going to have to respond within the normal time period. So there will be no penalty.
Right. Yeah, that's actually really important, because even if you were to file, the other party would their deadline really doesn't, it's not being enforced right now. So, right. So yeah.
Right.
Yeah. So yeah, this file pretty much covers what we just discussed.
Yeah.
It's if your filing and procedural deadlines are either suspended or extended until a given date. However, in the Court of Appeal, some judges will exercise their discretion to be mindful of the circumstances arising from COVID. So they will take it into
it's actually quite interesting, having spent way too many hours in the last week mired in all this stuff, that really the only courts that are doing anything other than suspend extending, anyone who's filed anywhere other than a Court of Appeal, you can stop worrying about that.
Yeah.
But in the courts of appeal, and again, it changes from province to province, and you can look on the website to see what the rules are. In the courts of appeal and in the Supreme Court of Canada, they are, in some cases at least, still requiring people meet deadlines, which seems ludicrous to me, especially given that there are no deadlines in all of the other courts, but they are still required in some of those courts. So if you are one of the very small number of self-reps who are in a court of appeal or Supreme Court of Canada, very unlikely, you should check on the website. And, you know, this clause here, I think, kind of covers them for the fact that people aren't going to meet these deadlines because, you know, either they're not going to understand that it's different because it's a court of appeal, or they're just not going to be able to meet the deadlines for all kinds of other practical reasons that apply to people's lives at the moment. So I think that what you're going to see is even where the courts of appeal are saying, well, in this court, we still have our filing and our procedural deadlines and timelines in place, that in future, it's very unlikely somebody will be penal. So, you know, in a way, as I said before, these slides, unless you're someone who is just itching to begin a case, these slides are actually kind of good news. These slides really are the pause button, and you don't have to have that clock ticking in the same way. Aisha.
So the courts are making they are allowing for some changes. Except for originating documents, you can now serve the other party via email or an electronic form. And this would, usually you would have to get a court order to allow for service by email. But in this case, they are making that exception,
right,
except for any application that would have been considered an original application. So, or you would have required that special service on the outset.
Could you explain what an originating document is, Aisha?
So, for example, if you were starting an application for custody, child support, or any other relief, then you would, the normal procedure is that you would have to file that application in court in person, and then you would have to take that application once you were given a date and serve it to the other party in person, not by email, not by fax, in person, and then you'd have to go back to the court to file an affidavit of service saying that you served it. So in that case, that would have required you to do that process in person, to serve that other party in person, special service. So for those applications, you cannot email because they're originating applications. But for example, if you were to bring a motion, that's not an originating application because there is an application already in place in court and you're just serving a motion, you can do it electronically.
Right. So if you already have a case in court and you want to file something that is a motion, for example, a motion to be heard urgently, it's an example.
Yes.
You can do that electronically.
Exactly.
But there is no...
You'd have to fax it. You would have to fax it and that would be okay. But in this circumstance, the court's saying, we will allow for the document to be emailed, and that's okay. So they're making that.
Yeah, and hopefully by the end of all this, the courts will have realized that in the 21st century, no one has faxes anymore.
Exactly. Right. Yeah. Exactly.
So the basic message here is if you haven't started your case, you're not going to be able to start it. If you've started it and you want to file something relevant to it, you can do so electronically. Right. If you're on the receiving end, you don't have to respond within a particular period of time. You can relax about that. Okay? Right. Yeah. That's sort of the bottom line here.
Yes.
And finally, this is the other little wrinkle, which is complicated to explain, but Aisha, have a go.
Well, it's sort of statutory limitation periods, the time you have to begin a claim. Well, right now, those are suspended, as I understand it.
Yeah.
So again, everything's on hold right now. None of this really matters right now.
Well, they are suspended, just to be clear, they're suspended in Ontario and British Columbia so far. They're not suspended in other parts of the country. Right. So for example, you have 6 years to bring a breach of contract or a claim.
Yeah.
Usually, and that runs when you realize that the injury had been done to you or the breach and you realize you have a case. the clock is not going to run on those claims in Ontario or British Columbia now. And I think we're going to see the other provinces follow suit. We just haven't seen them follow suit yet. So if you're trying to read your way through some of these court websites that use this language, when they refer to suspending filing deadlines and procedural timelines, what they mean is filing in court, filing documents, responding to the other side. When they talk about statutory limitation periods, these are in legislation, in statute, not in the rules, and they refer to the restrictions on how long you have to begin a claim. But again, you know, we are, I think, very unlikely to see this penalizing somebody whose statutory limitation period ran out during the period of the pandemic. Make sense, I hope?
Yeah, yeah. I mean, we're just all trying to make sense of it, but that's absolutely correct.
So as I say, again, if you have other questions about this, because you will see this language being used on some of the websites, then, you know, please ask us. And then another question is, because this changes everything, normally when you file an affidavit in your case to support the argument that you're making, you would swear that in front of a for oath or a lawyer or a notary public, as it's called in British Columbia. And that would require physically being in the presence of. After a slightly slow start, most of the provincial law societies are now putting together procedures for virtual commissioning, which basically come down to getting on a video call like this one with somebody who would ordinarily be the person's, you know, commissioning your document, testifying that it was in fact you making this statement, and doing that on the video screen. Now, some of the courts, and I hope all of the courts with this couple of weeks, some of the courts are saying we aren't going to require swear affidavits at the moment. File your affidavit with your own signature, with your date, and at a future point, we will probably ask you to commission it, to have it confirmed that this was in fact your signature and this is your statement. So it's, again, a little bit of a hodgepodge. You have to look at your particular court. And we're not talking about affidavits for making a will here, by the way, or something that isn't involved in court. We're talking about court documents. Court documents at the moment are either going to be sworn virtually or they're going to be sworn later. I actually did an expert affidavit for a self-represented litigant applying for leave in the Supreme Court of Canada at the beginning of this week. And we do these every now and again at the project. And the Supreme Court of Canada is still requiring that affidavits are sworn in the ordinary way. I signed it and I sent it to the court, and my feeling is, you know, just try telling me that this is not okay at the moment. So I think that we're going to see increasingly these requirements being lifted. But again, you can check on your website, your court website, to make sure about that. And I would certainly encourage you, as we have done throughout, if you're sending in an unsworn affidavit, you know, put a note with it saying, my understanding is that this will be acceptable and I am willing to have this document commissioned or sworn in the future.
Yeah.
Okay, we're nearly at the end of this. So, I really just went through those pieces. So if you want to look at the National Self-Represented Litigants Project page, representingyourselfcanada.com, you'll see we have a COVID page, which, as I said, we update all the time. It has all the information from across the country on these issues that Aisha and I have talked about today, and also on the practice as it's developing on affidavits. It also has some template clauses that we're going to be adding to that Aisha has worked on with me for parents who might want to propose some kind of an agreement at this point that you're making outside of the context of the court. And we would encourage you to look at those too. We're also going to be doing a webinar a week from today that will specifically look at how you might try to negotiate that kind of an agreement, a temporary, albeit temporary agreement with your opposite person, whether that is with a lawyer who represents them like Aisha, or whether it is with someone who self-represented themselves. And we're going to be talking in that second webinar about strategies for doing that, tips for how to do that in a smart way, how to draw up some kind of a written agreement and what it might look like. So we would certainly encourage you to come back or to tell other people about that webinar if you know somebody who's in that situation. And you have there Aisha's law officer's email. I don't know, say a few words in closing, Aisha.
Thank you. I just wanted to say thank you, Julie, for allowing me to be a part of this webinar. And I know it's a difficult time for everybody right now, and it's, we're all trying to work through this time, and I hope everybody stays safe. And if you have any further questions, please feel free to email me. Try to be as helpful as I possibly can. Again, I can't give you any specific legal advice, but if I can be of any help in just guiding you, not advice per se, but just to help you during this time, I'm happy to do that.
Thank you, Aisha. And thank you, everybody out there. You've been very quiet, so we don't have any questions.
We have a question Julie, we have a question that came in.
Oh, good.
Yeah, it says, the first question is for you. Do you see it?
Let me just move it and then I can get into it properly.
I can read it to you if that's helpful.
Right, yeah.
Okay.
Question for Julie. Where is your Order of Canada? Well, my Order of Canada is presumably going to take place at some point in the future when I will go to Rideau Hall and be given the Order of Canada. It seems to me like that's the least of everyone's worries right now, but thank you for asking. Aisha, the second question is for you. I'm going to read it so everybody can see it. If a motion to change not urgent can only take place once COVID is over. And the answer, I think, is basically yes.
Yeah, I would still work on it, and then gather your points and put it together for drafting. And I would still continue to do that, especially if it's based on arguments or evidence that has taken place during COVID. Things that the other party may have done that you want to take note of, I would definitely do that, and then sort of, see how it goes from week to week in terms of what's happening with the courts, and then go from there. So, yeah.
So if there are no more questions, we will sign off. But we're very happy to have done this today. And I hope, as I say, the recording will be available, the slide will be available, hopefully this afternoon on NSRLP's website. I want to thank my friend and colleague, Aisha Amjad, very much for her willingness to do this and to help us put this information together. And we wish everybody, please stay safe and stay well. And take care of yourselves, okay?
Bye now.
Bye now.